Members, we have a quorum. I call to order the meeting of the Bills Committee on Statute, Law, Miscellaneous Provisions Bill 2024. Before the end of the nomination period, the Secretariat has not received any nominations for the office of Deputy Chairman. And some members have suggested to me that we should have a Deputy Chairman. So in accordance with the rules of procedure, I am asking if there's a need to have a Deputy Chairman for the Bills Committee. If members think there is such need, the Secretariat will issue another notice to ask members whether we need a Deputy Chairman, and the nomination period will end at 5 p.m. on this Thursday. So please do not miss the deadline again. I will ask members if there is a need to have a Deputy Chairman for the Bills Committee. If there are no objections, and since we have members who have suggested that we should have a Deputy Chairman, so I will have a nomination period extended to 5 p.m. on this Thursday. Also, I would like to ask members if we should invite public views on bill. If we are to invite public views, the Bills Committee will post a notice on the Legislative website inviting members of the public and deputations to attend a public hearing or give written submissions on the bill. So I want to first ask, for this bill, Statute, Law, Miscellaneous Provisions Bill 2024, I would suggest inviting only written submissions. If members agree, that is, no public hearing will be held, and we will only post a notice to invite written submissions from the public. The public submissions that we have received will be passed on to the administration for reference, as well as for them to provide a consolidated response. We will now get into the scrutiny of the bill. The bill has 15 parts and multiple divisions, amending legislation in various policy areas involving multiple policy bureaus and departments. So I suggest that public officers can first discuss policy matters for one part and then go into clause-by-clause examination for this part. Once the part is completed, we'll move on to the next part. So again, I want to ask members, do members have any comments in relation to the aforementioned arrangements? If not, we'll first invite representatives of the administration to come inside the conference room. As this bill involves multiple policy bureaus and departments, we have many representatives of the administration today. If members do not have any objections to the arrangements that I propose, I would also suggest that we will scrutinize the Chinese and English texts of the provisions in one go. However, members are welcome to raise any comments at any time in relation to the Chinese or English text. I will read I'll go through the provisions a little slower so as to facilitate members' raising of any concerns and the legal advisor's concerns if necessary. Let's first refer to the bill, that is CB brackets 3349/2024. I will invite now Ms. Lorraine Chan, Deputy Solicitor General Policy Affairs Acting, to give members an overview, a review of the bill. I will also ask members to refer to the various documents prepared by the Secretary, that is LS 32/2024. That is the Legal Service Division report, as well as CB brackets 4746/2024 brackets 01 brackets 02. That is a background brief, and the letter dated 30th of May 2024 from the Senior Assistant Legal Advisor Acting to the administration. I'll also ask members to refer to the response given by the administration. Thank you. Ms. Lorraine Chen, please. Thank you. It has long been an approach of the administration to introduce omnibus bills to make miscellaneous amendments to various ordinances. The proposed amendments are largely minor, technical, and non-controversial, but are useful for the purpose of updating or improving the relevant legislation. With this approach, we would not have to give amendments in small batches. This is more efficient. In order to improve legislation, this has long been the approach adopted. We would also make straightforward adaptation of references which are inconsistent with the constitutional status of the HKSAR and repeal obsolete provisions in various ordinances. We have 15 parts in this bill, and we have in general two categories. One, amendments without adaptation of laws elements, that is parts 2 to 13 and 15. This involves roughly 20 ordinances and 12 subsidiary legislation. The second category would be amendments with adaptation of laws elements, and that would be Part 14 involving 29 ordinances and 44 pieces of subsidiary legislation. Chair, I would like to say that because we have to amend various ordinances and subsidiary legislation, I have a suggestion here because the parts are relatively independent, so I asked the Bills Committee to perhaps focus on one single part, discuss the policy matters, and then we can discuss the clauses, and then we can discuss the legal advice's questions and the reply given by the administration, and then we can move on to the next part. All right. Thank you. Members, any questions? None? Thank you. So, members, should you wish to ask questions when we get to a certain part, please press the request to speak button. Let me also say this. The administration said for Part 14 in particular, a senior counsel of the Law Reform Commission Secretariat and a senior government counsel will join us when we get to that part. All right, let's commence our clause-by-clause examination. But let me first deal with some administrative matters. I will first want to mark some future meetings. The first would be 14th of June 2024, Friday, 10:45 in the morning. I also want to reserve another time slot, 11:30 on 17th of June. That is a Monday. I expect on both days 2-hour sessions will be needed. For the purpose of scrutinizing the bill. We'll now get into the actual scrutiny of the bill. Will the administration brief members on the first part? Thank you. Thank you. The first part relates to the preliminary, that is the short title and commencement. As we have over 100 ordinances and pieces of subsidiary legislation to be amended, we need some time to clean up the electronic legislation for editing and publishing. We want to ensure that the public can access the updated copies of the legislation on Hong Kong e-legislation in a timely manner. So apart from parts 6 and 10, the other ordinances will come into operation on the expiry of 30 days beginning on the gazettal date. Part 6 and Part 10 will be different because for Part 6 in particular, it relates to the Criminal Procedure Ordinance amendments. It should come into operation on the day of gazettal or on 2nd of August 2024, whichever is the later. The reason for this arrangement is that the Wild Animals Protection Amendment Ordinance 2024 also amends Section 113C (1) (c) of the Criminal Procedure Ordinance. We want to prevent any conflicts of the amendments. We will have the amendment take effect on the day of gazettal or on 2nd of August 2024, whichever is later, as the amendments for the Wild Animals Protection Amendment Ordinance would take effect on 1st of August 2024. Part 10 are amendments to the Legislation Publication Ordinance, Chapter 614. It is to come into operation on the day of gazettal. This arrangement is to tie in with the work schedule of the verification of legislation in Hong Kong. There is an imminent need for us to have the new power to make formatting amendment to adjust the formats of certain database instruments so that we can publish the verified copies of legislation for public use by Q1 2025. Due to such urgency, we will have this part come into operation immediately.
For Part 1, the commencement date will be related to the subsequent provisions that which we'll be looking at. So we do welcome questions from members at this point, or we can have this discussion when we reach the particular sections. Any questions from the floor? No, not for the time being. Please continue. Part 2 of the bill relates to Cap 8, the Evidence Ordinance. Now we'd like to follow the flow here for easy understanding by both government officials and Legislative members. I will now invite the administration wing of the Chief Secretary for Administration's Office of Staff to brief you on the amendment. The amendment relates to Sections 39 and 40 of the Evidence Ordinance relating to the microfilm production. The definition film is admissible in civil and criminal proceedings. However, it was first drafted in 1970s, which now does not cover microfilming production by implementing computer output microfilm, or COM. As such, we are not sure whether the COM version can also be admitted by the court as evidence. So we propose to amend the definition of film in Section 41 of the Evidence Ordinance so as to include a microfilm, the production of which involves digital means, including computer output microfilm, COM, so that both will be captured by Sections 39 and 40 of the Evidence Ordinance relating to the records prepared by microfilm production for the admissibility of the prints made from the film as evidence in civil and criminal proceedings, so as to accommodate the evolution of microfilming technology in future. Any questions on either version of the text? If not, please continue. Part 3 relates to contracts for employment outside Hong Kong Ordinance. I'll give the floor to the Labour Department. Thank you, Chairman. Part 3 proposes repealing Section 11(1)(h) of the Contracts for Employment Outside Hong Kong Ordinance, or CAP 78. The ordinance seeks to provide protection to the indigenous workers with employment outside of Hong Kong and for low-wage workers earning an income below $20,000. So that's the prevailing wage levels for non-laborers. For Section 11(1)(h) of this ordinance, it refers to the Recruiting of Indigenous Workers Convention 1936, and as the convention, as mentioned above, has been abrogated, that is the Contracts of Employment Indigenous Workers Convention, we propose repealing the relevant section. Repealing Section 11(1)(h) of the ordinance will not in any way undermine the interests and protections for workers. Any questions? Either Chinese or English versions? If not, please continue. Part 4 relates to the Post Office Ordinance CAP 98 and subsidiary legislation. I'll give the floor to the Post Office. In relation to the Post Office Ordinance CAP 98 and its subsidiary legislation, there are two parts to the amendments. The first part relates to repealing obsolete provisions, including the obsolete services and functions of the Hong Kong Post that have either never been provided or have already ceased. These services and functions include money orders, telegraph money orders, postal notes. They come under Sections 3H and K of CAP 98, as well as private traveling letter boxes referred to, for example, in Section 3M of CAP 98, and the issuing of licenses to any persons to collect letters for transmission to China through the post office and to receive club packets from China through the post office. And that's Section 6.2 of CAP 98. We're also going to amend Sections 33(1)(b), (c), and (d) of CAP 98 in relation to the above relevant offences. There will also be saving provisions to the effect that the existing exemptions from liability provided under Section 73, 7, 3, and 4 of CAP 98 continue to apply to the government as if those subsections had not been repealed. As we propose to repeal the relevant references to money orders in CAP 98, we also propose to repeal Regulation 19 of the Post Office Regulations, or CAP 98A, A, which concerns the operational details of money orders. We also propose to amend an obsolete reference in Section 2.1 of Cap 98, that is Postal Department in the English text, to be replaced by Post Office. These are amendments that are minor, technical, and non-controversial in nature. For the second group of amendments, these are amendments with adaptation of law elements. The amendments will not affect the services currently provided by the Post Office. Any views? Now, I'd like to remind the administration that as we go through the text clause by clause, please read the relevant text with better clarity. Next, Part 5. Immigration Ordinance, Cap 115. The Security Bureau will lead this part. Thank you, Chair. Members, please speak into the mic. Sorry, Chair, members. Am I coming through? Part 5 to the bill relates to proposed amendments to the Immigration Ordinance. The Court of Final Appeal made a ruling earlier in Prem Singh and Director of Immigration. To align the ordinance with the relevant ruling, the Immigration Department proposes to delete paragraph 31C of Schedule 1. According to Article 2424 of the Basic Law, a person not of Chinese nationality is a permanent resident on the condition that the person has entered Hong Kong with a valid travel document, has ordinarily resided in Hong Kong for a continuous period of not less than 7 years, and has taken Hong Kong as the place of permanent residence. The detailed arrangements for implementing this provision of the Basic Law are set out in paragraphs 2D and 3 of Schedule 1 to Cap 115. Before the Court of Final Appeal judgment, it was provided in paragraph 31C of Schedule 1 that a person not of Chinese nationality had to be settled in Hong Kong when the person made the declaration to the Director of Immigration that he or she had taken Hong Kong as his or her place of permanent residence in accordance with paragraph 31B of Schedule 1. In paragraph 15 of the same schedule, it provides for the concept of what is meant by the person being settled in Hong Kong. In other words, before the CFA judgment, non-Chinese nationals had to obtain unconditional stay status before they were eligible to apply for Hong Kong permanent resident status. After the CFA judgment, in order to align the provisions with the above judgment in the same year, for non-Chinese persons applying for Hong Kong permanent resident status, we have made appropriate arrangements in the same year to bring the requirement in line with the CFA judgment. In other words, the person would no longer be required to first obtain an unconditional stay status beforehand. In the same year, we briefed the Legislative Council panel on security. And we're now proposing the amendment as a result of our proactive exercise to review the relevant immigration laws. And in this same exercise, we'd like to propose a legislative amendment to bring the provisions in line with the CFA judgment. I urge members to support the amendment. Any questions from members? If so, please press the button. Right, I do have a question. You're going to repeal the provision relating to the declaration that he or she had taken Hong Kong as the place of permanent residence, etc. So this proposal is in line with the CFA judgment. Is that right? Thank you for the question, Chair. As soon as the Court of Final Appeal had handed down the judgment in the same year, the government introduced the same new arrangements. That means starting from that year, the non-Chinese nationals would no longer be required to apply for an unconditional stay status with the Immigration Department beforehand. Ms. Carmen Can. Apart from referring to which part we're talking about in the bill, could you also tell us exactly which page we're referring to in the marked up copy? Because you mentioned that those technical amendments which may straddle different pages. So that's my first request for the administration. Second point, I hope that the administration would elucidate the amendment with more details. I mean, they did a good job just now. They explained the judgment and what happens afterwards, what we need to do, or that this has actually been implemented. So this section should be repealed. So please do explain to us to help us understand the need for the amendment. Right, noted. Any other questions from members? If not, please continue and please take us to the page in the marked up copy. Some members might have come in late. Part 6, Criminal Procedure Ordinance, Cap 221. That's page 18 of the marked up copy, Chinese version. Also page 18 in the English version. Ms. Kwok from the LDD of DOJ will take us through this amendment. This relates to the definition of excluded fine in Criminal Procedure Ordinance. Section 113C of the ordinance provides that apart from the fines, if the fine provides a specific amount, then the amount will be translated into the appropriate level as set out in the schedule. And we have proposed 2 amendments. First, we add subsection BA so that excluded fine may cover a fine or penalty that is calculated by reference to unit of time or unit of measurement or a specified number of persons or objects. The next amendment relates to subsection C. It relates to fixed penalties. That means that the amount of fines has been fixed. We need to spell out clearly as a result that all fixed penalty in our legislation is excluded fine.
Ms. Doreen Kong. Thank you. I want to ask about the English text 1C. It says it is to be an ordinance. So here in Chinese it would still say an ordinance, but then in another part it would be in the Chinese text any ordinance. So why is it that you have to specify in Chinese that would be an ordinance? Thank you. Ms. Kwok. Thank you. This is exactly a concern raised by the legal advisor. And our answer is this. For we have a drafting legislation in Hong Kong, a guide to styles and practices that would be our current drafting convention, is to not use any if an indefinite article A or N can be used instead. But in the Chinese text, if we say specifically an ordinance, it may sound as if we were referring to one particular ordinance. This would be against our policy intent, which is why we would make use of any ordinance. So Ms. Doreen Kong's observation is quite correct. Before, we would have some provisions that would say any ordinance, and our drafting convention has changed in the sense that we will now adopt A or N instead. Thank you. But I want to ask, why is it that you haven't corrected the part for an ordinance in subsection 2 then? I understand where you were coming from. Since you're making amendments, why not amend the English version of subsection 2 where it says an ordinance then? Thank you. Ms. Kwok. Thank you. Well, first of all, we did not plan on amending subsection 2. It is correct as it is. So even with the change in our drafting convention and the original wording, there is no difference in the meaning. As long as people can understand the meaning, we do not plan on making amendments to subsection 2. Ms. Maggie Chen. Thank you, Chair. I want to ask for the paragraph BA to be added in section 113C. So it says here a fine or penalty calculated by reference to a unit of time or a unit of measurement. I want to ask what specific ordinances would have fines or penalties calculated by reference to a unit of time or a unit of measurement. I'll first have a response on this and then I'll ask other questions. Thank you. Ms. Kwok. Well, let me say for a penalty calculated by reference to a specified number of persons or objects. Right now for merchant shipping ordinance, that is chapter 369 section 39, if a shipping permit has been obtained and the number of passengers exceeds that on the permit, the penalty would be $20,000. And for each passenger exceeding the capacity, an additional $5,000 will be imposed, and this would be a penalty based on a specified number of persons or objects. So we thought with these different penalties, with different units, we think there's a need to amend the meaning of fixed penalty under excluded fine. If necessary, we can provide a written response providing more details. Chair. Yes, Ms. Maggie Chen, you want to ask other questions, correct? Yes, Chair. I also want to ask for the paragraph BA to be added. I understand where the administration was coming from. That is, we want to have more consistency and enhance public understanding. But I think we should also be clear to make sure members of the public are aware of the penalties. So for, in particular, subsection 2 of section 113C, there is a table for the different levels of fines, levels 1 to 6. We would often refer to fines by their levels at the moment. So I want to ask for paragraph BA. In the relevant legislation, will you also make such references to the fine levels to enhance public understanding? Thank you. Ms. Kwok. Well, the legislation is actually quite complex. Allow me to have more time to clarify this. The policy intent of the legislation is to provide levels of fines. But then, at the time, we could not handle all amendments of legislation at the same time. That's why we have provided ranges for the levels of fines, and we can have such converted. So would some people be confused as to whether it should be $1,000 or $2,000 and which level it would be? In fact, DOJ has amended most legislation for fines, and they would now say the levels of fines. I believe with our work in amendments in Q1 of next year, we will educate those in the sector or the general public that we have now adopted such legislation. We, of course, want to make clear what the penalties are. We do appreciate the conversion may not be easy for people to understand. And when people are reading Section 130C, it may not be immediately clear what the fines are. Thank you. Ms. Chan, any further questions? Yes, please. Thank you. Chair, it is indeed a complex issue. I want to make sure I'm clear when I'm asking my questions. My next question relates to 113C subsection 1. You have given a brief introduction for the amendment, but I want to ask, how is the added paragraph relevant to the legislation? I also want to ask, apart from the three references, that is a unit of time, a unit of measurement, and a specified number of persons or objects, are there any other units that are currently made use of in fines or penalties? Thank you. Ms. Kwok, please. With the penalties in the Criminal Procedure Ordinance, most of them are fines. There are other units in relation to civil proceedings, but because Criminal Procedure Ordinance is, as the name suggests, relating only to criminal penalties, so we would have the fines, and if they are over $100,000, they would not be included in the levels of fines. So we have added paragraph BA for other fines that are excluded in the sense that they would not be converted to levels of fines. Because, for example, for level 2, it would be $2,001 to $5,000. We have reviewed legislation and we have found some that are excluded should be covered with the added paragraph BA, and we believe we have dealt with such problem with this edition. Thank you. Priscilla, well, it's now my turn to speak. Thank you. So you mentioned we are now amending Criminal Procedure Ordinance. We are not amending other legislation at the moment. But when the time is right, would you ensure consistency by amending the other legislation as well? Thank you, Ms. Kwok. Since 1993, we have been asking policy bureaus to express fines in fine levels. With the fine levels, we would be able to amend the amount of fines if necessary, and every 2 or 3 years we would have some editing amendments to amend the existing legislation that have only amount of fines to be converted to fine levels, because we want to ensure it would facilitate the work of the legal sector and consistency. Well, thank you. I think this is a very important issue, and I hope that you will conduct review in a timely manner. Thank you, Chair. We do note your suggestion, and we have been conducting continuous reviews, and we will take your suggestion and review, if necessary, other legislation. Thank you. Ms. Lorraine Chen, thank you. We are now talking about Part 7 amendments to Hong Kong Auxiliary Police Force Ordinance. We'll have colleagues from the Security Bureau brief members on this part. Thank you. The amendments to the relevant ordinance is to align the discipline system of the Hong Kong Auxiliary Police Force with that of the Hong Kong Police Force, as provided under the Police Discipline Regulations, Chapter 232A. In accordance with Chapter 232A, there is a disciplinary offense in relation to conduct calculated to bring the force into disrepute. And in a 2008 case, Chu Hoi Po and Commissioner of Police, the English word calculated in the said offense would require a subjective intention on the part of the defaulter. It is believed that the word likely would be better because it would not require a subjective intention, and in fact the offense would be established even without subjective intention. In order to align the wording of the relevant disciplinary offense in Chapter 233 with that in Chapter 232A, which has already been amended, we will replace the word calculated with likely. So, in relation to the specific amendments for Chapter 233, for Section 14M, we will repeal calculated and substitute the word with likely. 2. Since Section 14M is amended, Sections 15(1) and 2, after petition, we have added in writing. So this part relates to appeal from boards of discipline. Again, this is to align the wording with that in Chapter 232A. We have also amended the part to say specifically, but made by way of petition in writing to the commissioner, that is the commissioner of police or deputy commissioner or the chief executive. And we have amended Section 26 of Chapter 233. This is a provision in relation to complaints to clarify that appeals from any decision of the commissioner upon any complaint by a member of the Hong Kong Auxiliary Police Force are to be made by way of petition in writing to the chief executive. We want to align the wording with that in Section 15. We have also provided some transitional provisions. That is, Section 14 of the pre-amended ordinance continues to apply as if the amending ordinance had not been enacted in relation to a member's committing of a disciplinary offense if the member is notified of the conduct of proceedings for the offense under this ordinance before the commencement date to prevent any confusion.
Ms. Carmen Can. Madam Chair, I'd like to confirm with the administration that in relation to the amendment to this ordinance, I am reading from the English text, likely and or conduct calculated to bring the force into disrepute, and that the word calculated is now replaced by likely. In terms of gravity, I think that using the word calculated, the offense becomes more serious. Now, in English, if the word is replaced by likely, it seems that the threshold is now lower and that the offense is not as serious. So is it the administration's decision from the perspective of policy consideration that this amendment is appropriate? I find it quite hard to express myself. Has it to do with the ruling? Can you say that this amendment is proposed not because the judge has expressed that the threshold is too high? In other words, you are not proposing the amendment because you need to adjust the threshold. Can you tell us, after the court has handed down this ruling, we are now proposing this amendment which is in line with the court's views and that the Civil Service Bureau has given it a thought? Who would like to take this question, please? Security Bureau? Who would like to take this question, please? Mr. Eddie Sid, Chief Superintendent. Now, I beg to differ from what the member said. It is not the case that the judge has opined that the threshold is either too low or too high. In the judgment, the judge has opined that there is inconsistency between the Chinese and English word in the provision in Cap 232A. That is why in English, the word calculated should be changed so as to bring the meaning of the provision in line with that in a Chinese version. It has nothing to do with the threshold. The judge is of the view that that section in Cap 232A, even in the Chinese version, does not require ascertaining the defaulter's subjective intent. So, in order to bring this piece of legislation in line with the disciplinary system for the Hong Kong Police Force, we are making the corresponding amendment in the English version. Any follow-up? Yes, Madam Chair. Before the amendment, can you explain where the inconsistency lies? The English version is conduct calculated to bring the force into disrepute. The Chinese version also refers to a deliberate act. So it seems that the court is suggesting that there is no inconsistency, and yet the English word has now been changed from calculated to likely. In the original version, 刻意致使 in Chinese is translated into the English word calculated, which I believe is consistent. In fact, I have another question on page 23 that is a similar amendment. I'm reading from the Chinese version, meaning likely, and yet there is no corresponding English amendment. So I want to know what the English word is. Are you referring to section 23, on which the judge has expressed his opinion that the Chinese and English versions are inconsistent? Mr. Sid, Chief Superintendent. I'd like to confirm what the member said. Indeed, in English, the word is calculated. In Chinese, is 刻意致使, meaning a deliberate intent. So these two are consistent. For calculated, for this word, the court is of the view that this word carries a subjective intent, and yet the legislative intent of Cap 232A is not to include the subjective intent element. So instead of using the word calculated, it should use likely instead. The Chinese version is copied from the amended version of CAP 233. As for Section 23 of CAP 233, that is in the Chinese version, from 很可能 likely to 相當可能 very likely. So English version, likewise, the word likely is used to mean 相當可能 in Chinese. Madam Chair, may I ask the administration to show us the amended version of CAP 232A, because I understand from him that the amendment has been put in place for CAP 232A, and you are making a corresponding amendment to the Hong Kong Auxiliary Police Force Ordinance. Yes, please give us a reply in writing. I have a question about Section 15, that is marked up copy page 22. You've added the words in writing after petition. But before including these two words, petition means in writing form, right? Yes, petition in writing. That has always been the case. Ms. Doreen Kong. Thank you, Chair. I have a question on Section 15 of CAP 232A. Well, in CAP 232A, Section 15.1, it doesn't say petition in writing. If you want to mirror 232A, then likewise, there is no mentioning of the words in writing after petition. Mr. Sid, or who would take this question, please? 232A, Section 15, subsection 1. Yes, please speak into the mic. Is it coming through, Chair? Right. Section 15 of CAP 232A. It says appeal by way of petition to the Commissioner, or in Chinese, 呈请书, meaning a written petition. If you want to align both versions, why can't you use the same terminology here? Because in English it's translated as petition. Ms. Lam? Thank you. Let me supplement on the point of drafting. The member's observation is correct. Indeed, the Chinese version in CAP 232A is 呈请书, and then in English is appeal by way of petition in writing to the Commissioner. So in Chinese, it means written petition or petition in writing. Coming back to Section 15 of CAP 233, in this context, we propose adopting the expression petition in writing, which is in line with the relevant section in CAP 232A. No other questions? Let's move on. Part 8 relates to District Court Ordinance CAP 336. That's page 26 of the marked up version in Chinese, or page 25 in the English version. For Part 8, the Department of Justice proposes to amend Section 84A of CAP 336 so that Sections 106 of the Magistrates' Ordinance apply to cases by way of case stated. According to Section 84 of CAP 336, the Secretary for Justice may instigate litigation, that means appeal by way of case stated, to the Court of Appeal against an order of acquittal. However, it doesn't spell out the relevant details. According to Section 84A here, in relation to the application, Sections 106 to 109 and 115 of the Magistrates' Ordinance shall apply mutatis mutandis. However, it doesn't spell out whether the relevant procedures apply to the appeals by way of case stated, and the Court of Appeal recently recommended in the case Secretary for Justice versus Zhang Hofei and 4 others that this part renders unnecessary difficulties, and that consideration should be given to amend the provisions. So here we expressly provide that the relevant sections in the Magistrate's Ordinance apply to the cases of appeal by way of case stated. Any questions? If not, please continue. Part 9. Water Pollution Control Miles Bay Water Control Zone Order Cap 358S. Page 27 of the marked up copy in English or page 28 in Chinese. The EEB will take the floor. Thank you. The EEB proposes to update Cap 358S in relation to the reference to the maps of the Miles Bay Water Control Zone in the Water Pollution Control Order. The proposed amendment to the schedule to the ordinance refer to a new series of maps which seeks to reflect the changes made to the Statement of Water Quality Objectives, Miles Bay Water Control Zone, Cap 358U, and the Fish Culture Zone Designation Order, Cap 353B, in late 2023. For the purpose of setting up new fish culture zones off Wangzhou Hai and Outer Tap Moon in the Miles Bay Water Control Zone for the adoption of new water quality objectives. These are the corresponding amendments in light of the proposal. They are minor and technical in nature. In the Fish Culture Zone Designation Order 2023, amendments were made to the schedule to Cap 353A, and then we also briefed the members of the relevant panel in February 2023 in relation to the setting up of the new fish culture zone. We consulted the relevant stakeholders, including the relevant fishermen bodies, the rural committees, and also marine culturists. The stakeholders were generally in support of the proposal. The EPD in September 2023 consulted the ACE on the Statement of Water Quality Objectives Cap 358U. The relevant maps were uploaded to the website on the 13th of December 2023. Ms. Carmen Kang. I have a question. You just read out this piece of subsidiary legislation, Cap 358S. Is it done by positive vetting or negative vetting? Since we are considering this omnibus bill, which includes amendments to relevant principal legislation as well as subsidiary legislation, I'd like to know how the Department of Justice informs the relevant government bureaus and departments. Did you tell all the bureaus and departments that they should grasp this opportunity and make proposed amendments? Is it supposed to be negative vetting at the outset? If they didn't ride on this opportunity, does it mean that this will be done by way of positive or negative vetting?
Thank you. Colleagues from the EEB, please. Or Ms. Chen. Thank you. We would want to adopt an omnibus approach, which is why we will amend this like we are amending any ordinance. I understand where the DOJ is coming from. Since you're introducing an omnibus bill, you have asked various policy bureaus and departments to submit legislative amendments to ordinances or subsidiary legislation, regardless of the nature of the legislation. So we are now going through the positive vetting procedures. If the subsidiary legislation can go through negative vetting because it is a piece of subsidiary legislation, why did they have to wait for this opportunity instead of having the amendments to the legislation made through negative vetting? Thank you, Ms. Lorraine Chan. Well, I believe the EEB has their own considerations. Yeah, I just want to clarify that. I understand where you're coming from. Let's let the colleagues from the EEB answer this. Thank you. Well, we would say this. Since the DOJ is introducing this bill, we are trying to introduce the amendments along with the reference to waters, territorial waters. Since we are making the amendment for territorial waters, we are amending the references to the new series of maps. It's just that it is the right timing that we have introduced such amendments. Well, let me say this. Is it the case that you have made reference to your administrative duties and it just so seems to be the case that you can introduce such amendments along with the adaptation amendment, and if not, you would just go through the negative vetting procedures, correct? Thank you. Well, Chair, I have a suggestion for the DOJ. Perhaps the DOJ can remind the relevant policy bureaus and departments that they should not wait until the introduction of an omnibus bill to make amendments. The last time a statute law miscellaneous provisions bill was introduced was in 2020. Or an omnibus bill. The last time an omnibus bill was introduced in 2020. So I asked the DOJ to remind policy bureaus and departments that they should not wait until an omnibus bill is introduced for amendments that can supposedly be vetted through negative vetting, and wait for that. Thank you. Ms. Lorraine Chen, please proceed. Thank you. We're now at part 10. That would be page 28 of the marked up copy. I will now let the relevant colleagues, that is my colleague from the DOJ, brief members on this part. Thank you. We would like to introduce with the amendments powers to make formatting amendments to database instruments, and that would be some editing amendments, that is font size, whether the certain words should be set in bold, for example. As such legislation would have to be published in a legislation in order to take effect. That's why we would need such powers to make formatting amendments. We have been running similar operations since 2021, and we have found some amendments to be necessary in relation to formatting. We will also amend the square bracketed cross-references in schedules. I will go through the provisions in detail in due course. Thank you. Any questions from members? None. Thank you. Now with the clauses, for the long title of legislation publication ordinance, we have added after ordinances and formatting amendments to database instruments other than the ordinances to give us the power I mentioned earlier. We'll now get to page 29 of the marked up copy. We have added a definition for formatting amendment. It means an amendment to a database instrument other than an ordinance made under section 14a brackets 1. We will now get to page 31 of the marked up copy. Section 4, it relates to contents of database. So for subsection 1e, it has the contents being the record of editorial amendments compiled under section 15. Any editing can be recorded in our system, and we want to make sure the records of editorial amendments can be made accessible to the public, along with the formatting amendments. Thank you. Please proceed. We're now on page 32 of the marked up copy. We have added in the heading, first of all, formatting amendments to the existing editorial amendments in record. Division 1 editorial powers. We have also made a minor amendment. And we have also amended this section in relation to powers to make editorial amendments. In section 12AA, the Secretary for Justice may, in an ordinance, if a chapter number has been given to the ordinance under section 11A, alter the title, short title, or citation of the ordinance. As you may have observed, citation numbers would be given to ordinances. But then, when it's online, it would only be a chapter number. And if a chapter number has been given to the ordinance under section 11A, if a title or short title or citation has been altered, we can replace a reference with the power given in subsection A. So citation number would essentially be a number assigned at birth to an ordinance, and we would have the power in subsection A and AB if references have to be replaced with changes made to the ordinances. Excuse me. Let me first ask if members have any other questions. Thank you. None. Please proceed. Thank you. We're now on page 34 of the marked up copy. We have a new power to make editorial amendments. We have schedules to various ordinances, and schedules would usually be more technical in nature. And in the bottom right corner, there would often be square brackets, and they would have some cross-reference numbers. And the cross-reference numbers would relate to, for example, the provisions in the ordinance. For example, section 3 of the ordinance. So with this power, we have observed before, because with our review, some cross-references are not amended in a timely manner. And unfortunately, some of such would be forgotten. We want to make sure with the cross-references numbers being erroneous, it won't affect the powers of the legislation. Which is why when we are amending editorial matters in relation to legislation, with this additional power, we can amend the cross-reference number contained in square brackets. As schedules relate to multiple provisions, we want to make sure the cross-references are valid in order to facilitate the legal sector or members of the public to refer to the relevant provisions. So the specific wording of the paragraph would be amend a cross-reference number contained in square brackets in a schedule to the ordinance, including the square brackets and any letters, characters, and symbols contained in the square brackets. But these would generally be quite minor, such as the various symbols only. Thank you. I have a question. So you would say in the relevant section AB1, you would say the other ordinance to say the reference ordinance. I want to ask which provisions you have referred to when you are saying this other ordinance is to be replaced with the reference ordinance. And what would the reference ordinance mean specifically? Thank you. Well, thank you for giving me the time to clarify this. We would have some references or cross-references, and these are technical in nature. So in Chinese, we would often just say references, but in English, we would say cross-references. Therefore, when the cross-references, it would refer to other ordinances. That's why we would say the reference ordinance. As for other legislation, we would have to look at the context of the specific legislation. So we may have a different wording. What would you use for searches in the English text you're referring to? Well, so references in Chinese have very clear meaning, but then in English there may be multiple meanings. So if it is a cross-reference, what would it be in Chinese? Well, it would have a longer Chinese name, that is, it would mean specifically cross-reference.
Please continue. Second division, or division 2, relating to record of editorial amendments, we add the word etc. And then subsection AB, descriptions of formatting amendments made. Please continue. Members, after page 36, when you reach page 37 of the marked up copy, can you read part 11 here? But there should be other amendments. Page 36, there is an amendment relating to the descriptions of formatting amendments, right? You've gone through that bit, right? There's another amendment, 14 capital A. Powers to make formatting amendments. The Secretary for Justice may change the format, layout, printing style, or any other presentational aspect of a database instrument. The effective date of a formatting amendment must not be a date earlier than the publication date, and it should specify in the record when the amendments will take effect. Apart from the record itself, we also need to add the footnote showing that there's been a formatting amendment. So likewise, members, when you look up a piece of legislation, you will find certain references to when the changes have been made to the Gazette. Any questions? Now for the larger bits like 14 capital A, you should read out the whole paragraph. I just did. So that we don't need to go back. Any questions? No? Right, because it's a newly added section 14 capital A. Right, any comments? Ms. Carmen Can. Madam Chair, for the expression database instrument, can you explain this expression? For the benefit of the public, can you tell us what a database instrument is? 14 capital A bracket 3, is that right? Whenever there is reference to a database instrument, is there a definition? Or perhaps we can go to the interpretation clause. Can you tell us what a database instrument is? Thank you for your concern. Database instrument means an ordinance, the basic law, and national law applying in Hong Kong, or an item of materials or information referred to in section 4(2)(b). In other words, we're referring to things that we put in the Hong Kong legislation for access by the legal profession and the public. We want to introduce a new formatting amendment for the database instrument outside of the ordinance, and this there is a definition in the interpretation clause. But the database instrument also refers to the ordinance. Why is it outside the ordinance? Because we have the power to make formatting amendments. We don't need to rely on this power. In fact, in section 12, it refers to the powers for the Secretary for Justice to make editorial amendments. It refers to the Secretary for Justice making editorial amendments from A to I of section 12. We believe that the only thing outstanding is a power to make formatting amendments. Let me put it this way, Madam Chair. The powers to make editorial amendments include the powers to make formatting amendments in the ordinance. So in this exercise, you add this provision that in relation to the database instrument, meaning an ordinance, a basic law, and so on and so forth, you do not have the power to make editorial amendments, but only the power to make formatting amendments. Correct. Please continue. Part 11. Private Healthcare Facilities Ordinance, kept 633, page 36 in the English version of the markup copy, and page 37 in the Chinese version. The Health Bureau will take the floor. Thank you. Chair. In 2018, the Private Healthcare Facilities Ordinance was enacted, and that's CAP 633, under which there is a complaint mechanism. The policy intent under this piece of legislation is to set up the Committee on Complaints Against Private Healthcare Facilities. This is a statutory body which could take complaints from patients against licensed private healthcare facility. Under Sections 82(1)(c) of the ordinance, a substitute decision maker of the patient of a private healthcare facility may make a complaint against the facility to the committee on behalf of patients under the age of 16 or patients that is mentally incapacitated. Members can refer to page 41 and 40 of the English and Chinese versions of the marked up copy respectively. And that for the term substitute decision maker, the interpretation should be made by reference to Section 3 of the Electronic Health Record Sharing System Ordinance, or CAP 625. We, however, find it inappropriate because the ordinance requires that the substitute decision maker has to accompany the healthcare recipient at the relevant time. That means there should be relevance to the time when the patient participates in the EHRSS. However, in terms of the context of making complaints, this interpretation may hinder the patient's or the substitute decision maker's rights to make a complaint. So instead of making reference to CAP 625, we propose to provide a clear definition for SDM so as to provide safeguards for patients who'd like to make a complaint against their private healthcare facilities in line with the policy intent. I welcome questions and comments from members. Any questions from members? Can you read out 8A, please? Please go to page 43 of the Chinese version of the marked up copy. Meaning of substitute decision maker. 8, capital A, subsection 1. A person is a substitute decision maker of a patient if the person is an eligible person under subsections 2 or 3. And then 2, for a patient who is aged below 16, the following are eligible persons for the purposes of subsection 1. A guardian of the patient appointed under or acting by virtue of the guardianship of minors ordinance or otherwise appointed by the court. B, a person appointed by the court to manage the affairs of the patient. C, in the absence of the persons mentioned in paragraphs A and B, a family member of the patient or a person residing with the patient in the same household. D, in the absence of the persons mentioned in paragraphs A, B, and C, the prescribed medical service provider that provides or is about to provide a medical service to the patient. It sounds complex, but for patients under the age of 16, the definition of a substitute decision maker is already provided in CAP 633. So there has been no change. For subsection 3, for a patient who is age 16 or above and who is of any of the following descriptions, the persons specified in subsection 4 are eligible persons for the purposes of subsection 1. A, being mentally incapacitated as defined by the Mental Health Ordinance. B, being incapable of managing his or her own affairs. And then 4, the following are persons specified for the purposes of subsection 3. And we're on page 44 of the Chinese version of the marked up copy, or page 43 of the English version. Let's stop here. Let's hear from 2 members. Ms. Maggie Chan. A question on substitute decision maker. You're adding section 8, capital A, to provide a definition, and then in the interpretation clause section 2, you propose to delete this definition. I'd like to know your logic. Why are you adding 8, capital A? Because after sections 6, 7, And then 8, you have interpretation of premises in relation to private healthcare facility. My first question is, why do you include the meaning of a substitute decision maker in 8 capital A? Because what comes next is section 82 about complaint against a private healthcare facility. So why do you put the definition next to 8? As a new provision 8A instead of putting it under section 82. The interpretation section can be found in section 2 in relation to private healthcare facility and substitute decision maker. And then there are other provisions relating to the other interpretation of terms from sections 3 to 8. So by putting 8A here, we'll have all the definitions at a glance. For sections 8 and 8A, I should think that these two are related. But 8A doesn't have anything to do with section 8. So I think you should add section 10 instead in the first division. Is it a better way, do you think, of expressing the term? Who will take the question, please? Dr. Sarah Choi or? Yes, thank you, member, for the question. Now we've decided to put the meaning of substitute decision maker in 8A, having regard to the structure of CAP 633. From sections 3 to section 8, or even section 9, these provisions provide interpretation of different terms. So it is in this order. In the order of the terms appearing in section 633, we provide these provisions. So in the same vein, we are providing the meaning of substitute decision maker in 8A and then another term in section 9, which both appear in section 82. And we've decided to put the meaning of substitute decision maker in 8A so that it follows the order of terms appearing in CAP 633. Ms. Doreen Kong. Madam Chair, in 8A to C, it refers to a family member of the patient. Is there a definition for a family member?
Thank you. In fact, the legal advisor asked us about this, the meaning of family member, and we have given a response. That is, we do not have a definition for family member in Chapter 633 before, because we want to adopt a more broad definition. I will talk more about the policy intent for members' reference. The policy intent for example, for voluntary health contributions, it would be limited to spouses and siblings and immediate family members. But then we have seen before that with the lodging of complaints, it will be more broad. For example, when people have immigrated or they have some trouble with their family, they would have distant relatives lodge complaints instead. So we want to make sure those who do not have immediate family members who can lodge complaints for them will not be rejected simply because of that. We therefore consider it appropriate to have a broader definition for persons eligible for making a facility complaint. Thank you. Yes, Mr. Kong. I actually referred to Chapter 1 Interpretations and General Clauses Ordinance. There has not been a definition for family members. I think we have a different context now. If you ask me, of course, lodging complaints is very important, and I understand where the administration was coming from to have a broad definition. I think you can specify whether a relative is a relative by blood. You can define that. I think there should be a clearer definition, and I don't think there should be any potential disputes on whether one is an immediate family member of a patient. I can share with you my experience. A client of mine has been trying to obtain registered particulars from the immigration department, and the department had reservations because they had doubts in relation to whether one was an immediate family member. We do want to ensure consistency across different departments. So I think we should adopt a clear definition for family members in order to ensure consistency. Thank you. Ms. Kamen Khan. Thank you. The administration's amendments would be about making clear the meaning of substitute decision maker and to not have a reference made to the electronic health record sharing system ordinance. I want to ask for section 8A with the categories that you have given, which legislation did you refer to? I want to ask specifically about 2D in particular. Because it would be in the absence of the persons mentioned before the prescribed medical service provider. And that would include the HA, the Department of Health, and the prescribed medical service providers. So it is that in the absence of guardians, parents, or family members, the prescribed medical service provider can still lodge a complaint on behalf of the patient. But the institutions, the possibilities are endless. So I want to ask what the justifications are for the administration for putting this here. Thank you. Can you speak into the microphone? Can you speak into the microphone? Yes, Dr. Sarah Choi. Thank you. The policy intent has not changed. And the provisions here are already in existing legislation. These came from Chapter 625. As for the specific questions of the member in relation to a healthcare institution, whether it would be a last resort, indeed it is the case. Because we have to ensure the patient would have the right to lodge complaints even if they do not have the other eligible persons present. So if a patient is mentally incapacitated and they do not have any eligible persons who can lodge complaints for them, if the patient is sent to another healthcare institution and the staff members of the healthcare institution have found out maltreatment from the previous healthcare institution, the healthcare institution then can lodge a complaint on behalf of the patient. It may be the hospital authority, the Department of Health, or any private healthcare institutions. So this would be a last resort in the absence of other eligible persons. Substitute decision makers, anyone residing with them, or the fact that they're not living in homes, we will still have other healthcare institutions that can lodge complaints on their behalf. Thank you. Well, I think the explanation, I would suggest that if there are other provisions that have referred to other legislation, the public officers can mention the referred legislation. So I want to ask, since you're only copying the provisions, have you found that there is the need that this section D may not be, or this paragraph D may not be enough? Do we need an even broader definition to ensure coverage for patients? I think the administration can think about this. Thank you. All right, Ms. Maggie Chen. I want to ask about priorities. So for Section 8A, subsection 2D, and 8A4G, we have referred to the different scenarios for a patient who is aged below 16 and a patient who is aged 16 or above. So is it the case that A would be the priority and the order would go through the alphabetical order? That is, a guardian will be prioritized in becoming an eligible person. I also want to ask, well, first of all, I'd like to express my support for adding Section 8A, but then in Section 82 of 633, Chapter 633, in relation to who can make complaints, it would be the next of kin and then the substitute maker. The first one would be the patient, of course. So basically, we have expanded the coverage. So in Section 82, if there is a next of kin of the patient, and there is a substitute decision maker who is a different person, if both of them want to lodge complaints, but they have different directions, how will priority be accorded? Are we following the order in Section 82 with the lodging of complaints? That is, we would have a next of kin that would prevail over a substitute decision maker. Thank you. Dr. Choi. I can provide more information for the members' reference. So for the Secretariat of the committee, the Complaints Committee, they would refer to legislation. No clear priority is accorded in legislation, but in general, the Secretariat would have the patient come first if they are not mentally incapacitated and age 16 or above. So we would respect the wishes of the patient first, if that is the case. And we would also prioritize those in Section 82 1D, that is, a person authorized by the patient in writing to make a complaint. In general, we would accord priority to these two categories because these would directly represent the wishes of the patient. In 1B, that would be the next of kin of the patient. So substitute decision maker would come after this. So a substitute decision maker would act on behalf of a person who is mentally incapacitated or age below 16. With the choice of next of kin, we would respect the wishes of the patient. If the patient wishes to essentially authorize the next of kin to lodge a complaint, we would allow for that to happen. Otherwise, the priorities would follow the order set out in Section 8A. Say in subsection 4, there are A, B, C, D, E. So we reference to Chapter 136 and previous court cases, there would be a substitute decision maker. So if A, B, C, D, E are not covered, then we would need someone else. Thank you. Ms. Chen, any further questions? So I want to ask if we have a specific example of a person aged below 16 who is not mentally incapacitated. Would it be the next of kin who can make a complaint, or is it the case that with the absence of the persons mentioned in paragraphs A, B, C, it would be the prescribed medical service provider? If both are fighting to lodge a complaint, who will prevail? Thank you. For a person aged below 16, we would first have the parents of the patient lodge a complaint. So in Section 8A, we would say in particular it would not be a parent, it would be a guardian. And it is very much different from a parent in terms of the definition. If in doubt, we have legal advisor with the complaints committee. We will consult the legal advisor if it is necessary. Any other questions? Yes, Chair. They say they will consult legal advice if necessary, but we are already referring to legislation. So I want to ask, in relation to drafting, who will prevail? Thank you. Well, Ms. Choi, can you provide more answers? I think I will adopt the answer that I gave earlier. Perhaps you can let me follow up on this to clarify this. So for Section 8A, if we are talking about substitute decision makers, is it the case that in some scenarios they would already have next of kin or parents that would essentially be substitute decision makers, and you would not need an actual substitute decision maker? So a substitute decision maker would be the case, essentially a last resort. And in the last resort of substitute decision maker, there is another last resort that is in the absence of the eligible persons. This prescribed medical service provider can lodge a complaint. So in my understanding, Section 8A relating to substitute decision maker is that if you have no family or parents, you would need substitute decision maker. So I would first like to clarify if my understanding is correct.
Correct. Because otherwise you wouldn't use the expression substitute decision maker. And the next point, 8A to C, as another member just clarified in terms of a complaint, I think that a broad or relaxed approach can be taken. discretion should be allowed in relation to the definition of a family member, like you explained. Members also ask other questions. Perhaps you can give it a thought in relation to whom a family member should be, especially in other pieces of legislation such as probate, succession. Here, it's for the complaint handling agency to decide. But it doesn't mean that this is a broad brush rule. In this context, is for the complaint handling mechanism to decide. For other executive authorities, such as the Immigration Department, which may also exercise discretion on the basis of policy consideration, there may be a different interpretation of what a family member is. This is correct, Chair. Indeed, we'd like to give some leeway for the complaint handling committee to handle complaints. Now, as I said, we've come across some cases in which the elderly patient may not have any relatives around or may only have very distant relatives. If we make it too restrictive, then the committee will need to turn down certain complaints lodged by people who are otherwise not eligible, and this may not be, this may be counterintuitive. Right, a short one, Ms. Chan. Please give me something in writing. Give it a thought about the correlations between sections 8A and 82. Because as per your explanation, if it's for the committee to decide on the priority, then it seems to be too much discretion to be given. Because, say, as I said, patients should come first, followed by the next of kin, and then substitute decision maker, and then the person being appointed to make a complaint, followed by the administrator of the estate. Right, if need be, please give us supplementary information. Page 44 refers to the arrangements for a substitute decision maker for a person above the age of 16. A. Being mentally, appointed as the guardian as per Cap 136, that's mental health ordinance. Now, like the member said, there is apparently an overlap between C to G, but that's not true. Now, according to 44(1)(I) of Cap 136, if the patient is placed under the guardianship of the Director of Social Welfare or any other person under that provision, then the person should be the Director of Social Welfare. Whereas for the other provisions, if according to the court, guardianship should be granted, then this applies. Next, if the guardianship of the patient is vested in a Director of Social Welfare under Section 44B2A or 59T1 of Cap 136, the Director of Social Welfare. Now, under this provision, the guardian of the patient might have passed away, or they might have written to the government relinquishing the guardianship, and when that happens, the Director of Social Welfare will step in. And then D, if the functions of the guardian of the patient are to be performed by the Director of Social Welfare or any other person under Section 44B2B or 59T2 of Cap 136, then the Director of Social Welfare or that other person. Now, in relation to functions of the guardian, Perhaps the guardian may be seriously ill to the extent that the functions may no longer be performed. So according to this mechanism, the Director of Social Welfare or that other person so appointed may take up the guardianship. And then next, a person appointed by the court to manage the affairs of the patient. This is a very broad category capturing the above. And then F, in the absence of the persons mentioned in paragraphs A to E, a family member of the patient or a person residing with the patient in the household. And then G, in the absence of the above, the prescribed medical service provider that provides or is about to provide a medical service to the patient. Like Dr. Choi said, this could be another private healthcare facility or the HA or the Department of Health. And then subsection 5 provides what a prescribed medical service provider means. Yes, please continue. Part 12. Patents Ordinance Cap 514 and subsidiary legislation. Page 45 in the Chinese marked up copy and page 44 of the English version. The IPD representative will take us through this part. Chair members, Part 12 of the bill relates to amendments to Cap 514, Patents Ordinance and its subsidiary legislation, namely the Patents Designation of Patent Officers Notice Cap 514A and Patents General Rules 514C. In 2018, or specifically on the 28th of August 2018, the English title of 國家知識產權局 has been changed from State Intellectual Property Office to China National Intellectual Property Administration. There is no change to the Chinese title. To reflect this change, we propose to update the relevant references to the 國家知識產權局 in the English version. The proposed amendments relate only to the change in the English title of the authority as mentioned. These changes are minor and non-controversial in nature, nor will they in any way affect the operation of the relevant provisions. I will take members through the amendments in Part 12 now. Please wait. Ms. Doreen Kong. Madam Chair, I checked the version of the IP or the patent law of the People's Republic of China in Article 3. In Chinese it says 專利權. In English is translated as patent rights. So, I think instead of using just the word patent, if we're referring to matters relating to 國家知識產權局 or the China National Intellectual Property Administration, we should use the term patent rights instead of patents. Now the Chinese title reads 國家知識產權局, which deals not only with patents but also other applications of relating to intellectual property. So the title in English reads China National Intellectual Property Administration. Chair, I don't think the point has come across. This administration grants patent rights specifically in the PRC law, especially in Article 3. In the English version, the term we use most of the time is patents, but it's equally sound to say the patent rights. So we should make reference to the national law and adopt the same terminology, in Chinese meaning 專利權 and in English meaning patent rights instead of just patents. Right, before I invite the administration to answer this question, I will extend the meeting by 15 minutes because I want to finish part 13 today. because, as I explained to members, when we reach Part 14, we will be moving on to another group of amendments. So for the sake of consistency, we should strive to finish Part 13. We also have representatives from the administration waiting here. Well, we usually express the granting of patents as such in the English version. The terminology is also consistent with that adopted in other pieces of legislation. Now, my question is this. The Mainland Authority changed its title long ago in 2018, and we didn't do it until now. So it's a long wait. And I also understand what Ms. Doreen Kong said. In Hong Kong, we use the terminology patent and 专利 in Chinese, but you can give it a thought. My concern is on why it has taken so long to change the title. The Patents Ordinance was last amended in 2016 in order to introduce the OPG system, and we have been reviewing the implementation to see whether there is a need to further update the ordinance. We have yet to update the English title of 國家知識產權局, meaning State Intellectual Property Office, because we didn't have the opportunity. Riding on this exercise, we proposed to update the English title to China National Intellectual Property Administration. Right. You need to keep in view the development because we need to get ahead. It's all about patents. So make sure the title is updated in time. Every now and then we have the omnibus bill, but you can also initiate this exercise because we've waited for 6 years. Ms. Carmen Can. I agree with your observation, Madam Chair. As I said just now, I hope the relevant bureaus and departments would also keep in view the latest developments and make sure that under their portfolio the relevant laws are kept abreast with the times for the purpose of delivering public services. Now, I see some inconsistencies in the two amendments on pages 46 and 47. For the China National Intellectual Property Administration, it includes granting of patents for inventions and patents for utility models. That's the amendment on page 45, but on page 46, the last bit is missing, meaning the patents for utility models. That's true. In amending the Patents Ordinance, we consider the amendments necessary. Under the current system, an applicant may make an international application under the Patent Cooperation Treaty. Once the application moves on to the national phase in the People's Republic of China, an application can be made with the authority for a short-term patent to be granted. So this relates to the work of the China National Intellectual Property Administration. About this international application moving into the national phase in the People's Republic of China, it can apply for granting of patents for inventions or patents for utility models. And that's a simpler way, and that is why the amendment entails both ways.
As for what the members said about page 46, of the marked up copy. This is the interpretation in patent's designation of patent office's notice. So if one is applying for a patent in the Hong Kong scheme for standard patent by re-registration, they would need to submit to the CNIPA a standard application lodged with the CNIPA. But these will only relate to patents for inventions, not patents for utility models. Well, Chair, I think this approach is inappropriate because I think the CNIPA has its own definitions and they would adopt a consistent approach. If they have granted patents for inventions and they have granted patents for utility models, the administration is essentially posing restrictions to itself. Why are they doing this? Why are you tying your own hands? Why are you limiting yourself to a single type of application when the CNIPA has multiple pathways? It's not the case that you are trying to provide an exhaustive list here anyway. Well, Mr. Lau, you do note Ms. Carmen Khan's suggestion, right? Yes, we do. And I would say this, we are amending mainly the English name for the IP administration of China. All right, thank you. I will first invite Ms. Lorraine Chen to talk about the other amendments. Thank you. We will refer to page 54 of the marked up copy. This would be part 13. I'll let my DOJ colleague brief members on the amendments. Thank you. The amendments relate to mainland judgments, reciprocal enforcement ordinance, chapter 597, mainland judgments in matrimonial and family cases, reciprocal recognition and enforcement ordinance, chapter 639, including its subsidiary legislation. The two ordinances relate to reciprocal enforcement of mainland judgments and Hong Kong judgments. And specifically, these would relate to enforcement of mainland judgments. And these ordinances contain references to the High People's Court. The English text right now would say Higher People's Court. With the translation provided in the 2021 notice issued in Supreme People's Court, it would be High People's Court, and we find it necessary to align the wording to prevent any confusion. So pages 54 to 59, we have made amendments to Chapter 597, Chapter 639, and Chapter 639A to reflect that. In the English text, there's no change in the Chinese text. Thank you. Do members have any questions? I believe it is just an amendment with the English translation. It is a minor amendment. We have scrutinized parts 1 to 13 today, and I will say this. The next meeting will be held on Friday at 11. Is that correct? (11 in the morning). We will commence scrutiny of part 14. I believe that will be much discussion for part 14. I thank public officers from various bureaus and departments for coming today. We have made good progress today, and meeting is adjourned. There is no other business, seeing that this is the case. Thank you.